Risky exporters. Risky exporters is the last topic. I'll take 15 minutes here, okay. So see, what is risky exporter? Risky exporter means there is a tag, there is no legal term in GST law, risky exporter koi section and all that. No, there is legal backing, but there is no particular terminology in GST law called risky exporter. Risky exporter kya hota hai, sir? There is something called Directorate General of Analytics and Risk Management, DG हम बोलते हैं उसको, और क्या बोलते हैं, DG Systems और RMCC, Risk Management Center of Customs. ये सब क्या है? They see your activities. They see कि आपका L1 immediate supplier, L2, L3, L4 in your supply chain. Who is the person who is doing any fraudulent activity, issuing invoices, no supply of goods? Whether if you are an exporter, whether the HSN of the goods which you have bought is the same HSN which you are selling. How frequently you are buying, how frequently you are selling. They will see in their risk parameters that whether the same customers are there or same suppliers are there. They will see whether there is any case of inflation of export value mentioned in GSTR 13B. Many of us would understand there are two concepts. For the purpose of refund application in section 54, read with rule 89, which is your accumulated ITC refund. What is the export value which we put in statement 3? That is lower of FOB value which is in shipping bill or the invoice value in the tax invoice. Lower of that. That has become law as per notification 14 2022 dated 5th of July 2022. It has become law. But that is only for the purpose of refund. But actual GSTR 13B में क्या डालना है? FOB डालना है क्या? CIF में किया FOB डाल देंगे? अरे why? अरे actual transaction value section 15 valuation जो rule है, it is not different for domestic supply, different for export supply. No. If you are doing CIF, your insurance, your freight, all of that needs to be included because it's a part of your actual supply. So you are going to mention the actual your transaction value mentioned in your commercial invoice, mentioned in the invoice value in your shipping bill, in your GSTR 1 and 3B. But I am a very unscrupulous person. I want to inflate this so that I can set off more chunk of my input tax credit against it, and when I am making export with payment of tax, I will get more refund. Try to understand what I am saying. Every month refund मिलता है, पता है ना? When we make payment of IGST with export. So what happens is we file shipping bill is stamped. We file GSTR 1, now GSTR 3B also needs to be filed, and we get automatic refund from customs. No GST involvement. Right? So those particular cases, all of those parameters will be seen. Right? Now, क्या cases है sir? All those fraudulent cases only, which I mentioned. Their risk parameters, all of those things are there. They are seeing that you're inflating the value, you're buying from different suppliers, those suppliers have been adjudged to be bogus, all of those things. So they can give you an alert. Who will give the alert? RMCC. The Directorate General of Systems will issue an alert कि risky exporter है. कहाँ पर alert जाएगा? It will go to your Chief Commissioner of Jurisdiction and to the RMCC, that is the Risk Management Center of Customs all over India. आप सिर्फ CC1 CC4 से आप करते हो, यहाँ से हल्दिया क्या कैलकाटा ओवरसीज से आप एक्सपोर्ट करते हो. No, all over India. ED exchange data interface all over India. In all the ports it will be mentioned you are risky exporter. इसका मतलब क्या हुआ? 100% examination of all the export consignment before it goes loading. Second thing, that your refunds which are there, which I am mentioning, this payment करके जो refund आता है and all that will be stopped. All that will be stopped by issuing of RFT 07. You will see all that. So cases क्या है? मैंने बोला ये सब cases है. The board thinks that you have, अगर आप refund ले रहे हो accumulated ITC का under rule 89, so you have claimed input tax credit on the basis of fraudulent invoices. माल ही नहीं मिला, export कर रही है, माल ही नहीं मिला from the supplier who is bogus. So you are claiming erroneous fraudulent refunds. वो गलत है. दूसरा है, if you are setting off fraudulent input tax credit against output tax liability on the export, payment of IGST with export. So in that case also it's fraudulent. You are setting off input tax credit which is fraudulently whatever claimed, right, against the output tax liability. Third thing is, as I told you, inflation of export value, right, to get more refund. So these are the cases. Sir, we must be knowing these amendments which I have already mentioned to you. Here, as I have already mentioned this particular part, 100% examination and giving out the alert all over India to all the EDI ports. Now, sir, सिर्फ इतना बुरा नहीं हो सकता. रिस्की टैग मिल गया है, 100% मेरे को एक्सपोर्ट का कंसाइनमेंट का चेकिंग हो रहा है, रिफंड्स भी सब हो गया है, मतलब कि बंद हो गया, धंधा कैसे करेंगे? वो सब कुछ नहीं. ऑल दीज कैन ऑल्सो हैपन टू अस. सेम थिंग विच वी हैव डिस्कस्ड विद द लास्ट 2 hours. Summons section 70, inspection inquiry confiscation 67, arrest 69, we've discussed all of these. Provisional attachment of bank account 83, we've discussed this. Draconian rule, blocking of input tax credit for 1 year. All of these things can happen if you are a risky exporter. Now sir, whether this risky exporter, it has any backing, कि ऐसे मन धड़क ऐसे करे? Yes sir, it has a backing. Amendment, this notification 14/2022, retrospective from 1st of July, क्या बोलते हैं? In cases where I have reason to believe कि I have to verify the credential of this exporter, or he has purchased from some supplier who has indulged in any fraudulent activity, I will withhold the refund. So this is the particular rule, Rule 96 sub Rule 4, which it mentions, as per data analysis and parameters, I want to deeply examine the availment of this input tax credit before allowing refund. So in that particular case, withhold the refund. Right? Now sir, what happens is the earlier method which used to happen. Risky exporter 14 days se milta hai as per circular 131 and all for verification of the entire thing. 14 days. Nobody knows this. 14 days, stringent timelines. They are taking 2 years. No verification report. 2 years, 2.5 साल से refund मेरा पड़ा हुआ है. 60 days में refund होना चाहिए from the date of application of RFD 01. But 2 साल से मेरा फंसा हुआ है. Because they are not submitting the verification report which they are supposed to submit in 14 days. So earlier क्या होता था? Custom officer के पास में port में कहा है, how do I know? How do I get in touch with the custom officer? Where do I submit? Who will give me the verification? How will I prove my case? Then amendment happened last year on 28th November. Extremely important. Here the refund case is transferred from the custom port to my jurisdictional refund officer. I can go there. Ruby में मैं जाऊँगा. मैं यहाँ पर Clive Row में जाऊँगा. I know my refund is there with the officer. I will meet him. And I will ask him and request him, sir, 14 दिन आपको मिलता है circular 131 के अंदर में, please finish my verification. I am willing to cooperate and give you hundreds of documents. And if he does not cooperate in 14 days, please go to the higher authority or file a writ. We will see the safeguards and all that. But rule क्या है sir? Try to understand. वो refund application of 5 crore rupees which I am getting every month because of payment of IGST with export, which with on the basis of shipping bill and GSTR1, that is stuck for 2 years, but that is transferred to my jurisdictional officer. That entire refund application converted into RFD 01 by the system, IceGate to GSTN. So GSTN now makes a beautiful RFD 01 application as per Rule 89 and Section 54, and it has to give that particular refund in 60 days as per Section 54. Now that particular case he has to verify, do everything, he has to issue it in 60 days. Now it needs to be a full, all of these things, need to be there, right? Now, what can he do? He can't give you a deficiency memo. Sir, we know deficiency memo RFD 3. कुछ गलती हुआ है, इतना मेजर गलती हुआ है कि वो रिफंड ही खारिज हो जाएगा. Please apply again. He cannot do that because RFD 02 has already been issued. Because the GSTN has converted from IceGate that particular application and made it into an RFD 01. RFD 02 automatically acknowledged मिल गया मेरे. So RFD 03 cannot be issued. RFD 08 can be issued. Show cause notice can be issued. I am going to ask you for reasons why I should not reject this. Or RFD 06 can also be issued. Now, sir, this amount can be withheld. 100% examination of my export consignments. मेरा ये सब चीज़ हो सकता है. और क्या बुरा हाल हो सकता है? Sir, refund है. Can that be adjusted? Can that be adjusted? Yes, it can be adjusted. Law says, Section 54, subsection 10. You have not filed any GSTR 3B. Your refund has been transferred. You are a risky exporter. They are not paying your refund for 2 years, it is pending. You have not filed for 1 month, GSTR 3B, they will settle. Do best judgment assessment, they will settle. Or any order is pending, they will appropriate the refund amount, right? So, here it is, these are particular law which I mentioned. Now, what are the safeguards? Safeguards are, see, can registration be invoked? Sir, these are case laws, judicial pronouncements are safeguards. Can registration can be revoked? Cancel कर देंगे क्या हमारा registration कि हम risky exporter है? हम कोई fraudulent आदमी से माल खरीदे कि हम कुछ भी गलत काम किए? No, they can't do that. As per Section 29, read with Rule 21 of cancellation, कोई रूल ही नहीं है, प्रावधान ही नहीं है. प्रावधान क्या क्या है? 10-12 प्रावधान है. 6 महीना तक फाइल नहीं किया 3B, QRMP है 2 क्वार्टर तक फाइल नहीं किया, वॉलंटरी रजिस्ट्रेशन है 6 महीना तक काम स्टार्ट नहीं किया. 1 और 3B में बहुत डिफरेंस है. All of those things are there. So many things. This is not there. So we can obviously have a safeguard. This is a Delhi High Court in Manvi versus UI. You cannot, whatever, there is no provision to revoke your registration. Verification completed, sir. L1, L2, L3, L4, L5, L10 तक है. And उसमें से कोई supply chain में L5 है, वो धोखाबाजी किया. But my immediate supplier L1, he is genuine. You have done the verification in 14 days, 14 months also you do. But if you have verified the legitimacy, genuineness of my supplier, immediate supplier L1, please release my refund. Why are you waiting? This particular case law, Choksi Exports, hundreds of case laws are like that. They mentioned if the direct suppliers, they are not suspicious, please release the refund. Am I responsible to check the genuineness of L2, L3, L4, L5, L6? धंधा करे के पीछे भागे? Who are these people? I don't know कहाँ कौन से स्टेट में है. There is no provision in law where it is mentioned that I have to go and I have to verify my L2. से बोलते हैं ड्यू डिलिजेंस करिए फॉर L1 when you get into the transaction. That is fine. I have done due diligence. He was registered. But in this case, the department is saying, sir, बहुत टाइम लगेगा, 2 साल लगेगा, 6 महीना लगेगा. We cannot commit. We are doing investigation. No. Please, if you verified L1, release the refund. Compensation, extremely important. Sir, सिर्फ refund नहीं चाहिए, ब्याज चाहिए हम लोग को. हम लोग के साथ में गलती हुआ है. What does this mean? This means that when the refund from the port is coming to our GST and our jurisdictional officer, it comes 60 days from the date it has been converted into RFD 01. He has to issue refund. Otherwise, there is section 56, extremely important for us as a matter of claiming interest up to 6% on the duration, 6% per year. मतलब 1.5 साल तक 6% तक मेरे को interest चाहिए. And I will file a petition under section 56. I want refund. Not only refund, but I want my interest. And they have, the department has to pay interest. It's a big shame for them that they have to pay interest on the refund also. Same case here, risky tag cannot be forever. आपको ये समझना है, risky tag एक बार आ गया and all that. No, not forever. This risky tag आ गया, it is for 14 days as per the circular 131/2020. If they decide after 14 days that no, he's still a risky person, उन लोग alert नहीं देंगे to change it. RMCC has it, DG Systems has it, okay fine. I am convinced that you still are a risky exporter. So, but you need to have a proper trail, sir. You cannot just cry and say that, sir, I am a risky exporter. No, you after 14 days you have to go to your jurisdictional officer. You have to say that, sir, what is the verification report? I have submitted more than 100 documents. Please tell me. He said, I will need time. Go to a superior, additional commissioner, joint commissioner, write letters, make a case. Or if your case is very strong, you say that I have not done any fraudulent activity. Please file a writ. You will get safeguards, right? So RFD 07, which I have mentioned, which is for the withholding of the refund, right? RFD 06 is the sanctioning. So RFD 07 is mostly issued. Sir, we should do all of these things, maintain accurate records. We don't get input on your capital goods. We should extremely important, we should know from 1st of January 2022, this slide, I think this slide, please refer to this slide, one last slide, this one. This second paragraph. From 1st of January, this circular, from 1st of January 2022, retrospective, as sir was saying that we should tell the department and the government that there should not be retrospective effect which is adverse to us. There are so many case laws wherein it has been challenged that how can you do something which is retrospective and which is harmful for me? Because at that point in time when I did that, I did not have any clue that it will turn against me due to retrospective effect in the future. So what does this say? This says that from 1st of January 2022, the refund which we are applying for unutilized input tax credit under rule 89 for export under LUT bond, we have to follow GSTR 2B, not 2A. What does this mean? If the input tax credit is available in 2B in January 2020, in January 2022, in February 2022, then only we will get credit, refund. We will not get earlier. क्या होता है सर? 2A क्या है? Dynamic है. Dynamic का मतलब क्या है? बात समझिए. मेरे जो सप्लायर है उनका है अप्रैल 2022 का उनका बिल है, वो फाइल किया अगला साल में नवंबर में, अक्टूबर में फाइल किए. तो 2A में मेरा कहां पर आएगा? 2A में मेरा आएगा अप्रैल में पिछला साल का. तो मेरा वो रिफंड पीरियड में आ रहा है. आई कैन अप्लाई दैट पर्टिकुलर रिफंड इन दैट पीरियड. 2B अब बोलते हैं 2B मैंडेटरी हो गया. 2B में तो आएगा ही नहीं, आ ही नहीं सकता. 2B में कब आएगा? 2B इट विल कम इन नेक्स्ट ईयर अक्टूबर में. तो क्या 1.5 साल तक बैठे रहे क्या? We will not apply for refund. It will get time, but in 2 years. Extremely draconian. And this become law. 2A, 2B. Extremely technical. But now, अगर 2B में from 1st of January 2022 law has come out, section 16 subsection 2 clause AA read with amended rule 36 sub rule 4, that ये rule बन गया है condition. If your input tax credit is not available in your 2B, you cannot claim in 3B. तो वैसे ही refund के लिए भी कर दिए. 2B में 1st January से अगर 2B में नहीं है, so we cannot claim that particular refund in that tax period. Wait for the supplier to file it whenever he wants to. Wait, then file a cumulative tax return. Your refund for that tax period. Right?